Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. For those who don't know, the last few weeks we've had a new format. Basically, we go 30 to 40 minutes each show, and we dive right into our domain disputes. Those are usually 3 UDRP cases that we review and talk about. It makes it much nicer for replay when you know you got about 30 to 40 minutes of specific content instead of some of the fluff before and after. So we thank you for joining us. There's 3 hosts to the show. My name is Todd Ryan. We have David Michaels and Jeff Neuman. I'd like to say hello to my co-host before we get rolling for the day. Hey, David, how's everything going?
Good. The sun is out. It's a comfortable day.
Phantasm. Remember that movie Phantasm from like when I was a kid? It was awesome. All right, and then Jeff Neuman, stranger, as the boats pass through the night. No, Jeff hasn't been around, been fairly busy the last 4 to 6 weeks. But anyway, so Jeff's back and loves the new format. This is something that I know he can handle easily each week. But Jeff, nice to have you back. What's going on?
Hello. You were coming off a little bit muffled to me at the end of your sentence, so I'm hoping it's not me, my hearing, but I'm good and looking forward to getting back into it. A little jet lagged, but otherwise pretty good.
Good. I hope my
Welcome,
audio is,
welcome back, Jeff.
yeah, yeah.
Yeah,
Welcome back, Jeff, of course. But
test your audio again.
is it seem like it's okay?
Yeah, now it seems good.
Yeah,
Kookaroo Chicken, come in. Boston Market, remember those places? Yeah, they come and go. All right. Well, first I
I
wanted to
thought you were going to
say,
say Kenny Rogers Roasters. That's a blast from the past.
hey, Jeff, just the quickest recap possible. So that last ICANN meeting, anything you recall from there? Now that it's been several weeks since that last ICANN meeting, anything come to the top of your mind that you remember from the ICANN meeting?
Yeah, I think the biggest thing is it's the new TLD round has started and it um, was already, the window was open during the meeting. And if I think back to ICANN 2012, when the window was open, it was very chaotic, lots of questions, just, everything was all just discussions about new TLDs back in 2012. I was kind of struck by the lack of discussion this time around. I mean, not to say that obviously there were lots of people talking about new GTLDs and bidding, but not with ICANN. It was mostly side meetings and business meetings about new GTLDs. It wasn't really, there were no big issues discussed at ICANN, on actual ICANN meetings on the new GTLD rounds, which means that it's going rather or fairly smoothly. Um, Lots of discussion about there's a system at early warning.report, which is trying to come up with a pre-contention resolution. A whole complex system. Don't want to get into it now, but if people wanted to get into it, could discuss it on a different show. But other than that, it was what struck me was the lack of how smooth everything's running, which is unusual, but good.
Yeah, I was thinking, and now it's right in the middle of the application window. I still think, and you and I'll discuss this, having another 30, 45-minute show just to discuss it. It's so exciting, Jeff. I mean, I know, you and I working with a lot of applicants. It's fun working, there's different types, brand applicants, community applicants, open applicants. Um, and we are very happy to take on some new clients, even though the window is only about 5 to 6 weeks left of the remaining window. I know we have an introductory call with a new client tomorrow. Very happy to take on new applicants. But Jeff, so when would you say, this is for people listening on replay, if they absolutely want to work with, well, work with us certainly, when would be a deadline? And I mean, basically, sometimes people think, well, it's already, there's only 6 weeks left, 5 weeks left. I guess I need to wait until the next window opens in, well, 10, 15 years from now. Um, how much longer would we be willing to take on new clients?
Yeah, the interesting thing is you and I could turn these around fairly quickly if we had. The hard part is the customers getting all the information they need, setting up everything they need, bank accounts, making sure they're fully funded, drafting the answers, especially for just a regular run of the mill, either brand TLD or open TLD is it, not that challenging, really. But the customer, the actual applicant itself, having to know all of the answers to this, that's what really takes the time. Everything, especially if they're setting up a new entity, or they got to get their investment money in. They have to have an established bank account with funds already in it, enough funds already in it to show ICANN that you're serious and to show them that you can handle and you're prepared for the financial challenges that will be involved in running a TLD. So to me, that's really kind of the hang up is, you know, getting all that in place. But as far as you and I doing the application itself, you know, in the next 2 weeks would be kind of the latest. So by mid-July at the very latest. But again, it's really not us doing our work. It's more the applicant having everything in place.
Yeah, and thanks for those listening. So if you still intend on applying, or if you have interest in applying and you think, I don't want to let this window pass, reach out to us now. You can reach out to Jeff at JJNSolutions.com or Todd at JJNSolutions.com. And I say that because, right, usually the first week or two, we're telling our clients, gather this information, and this information, and then that way, we'll take it from there. But there is plenty of information to gather. And if you're a brand, it's about making sure that you have your, basically proof of your trademark, which is not too difficult, but now there could be a line. So that's something, if you're an open TLD, you just want to make sure you got your financials ready. So it's really like Jeff said, we're ready to help. We've been working with several clients, and I look forward to when this window closes, so we can also discuss a little bit more about the work we've been doing. But Jeff, it's been I'll say this to you, it's been a pleasure working with you. I've learned a lot, and our clients, we're right in the thick of it now. But it's an interesting time, and I cannot wait until the window closes. So then, then ICANN can start doing their work reviewing these applications. And anyway, okay, so we want to jump to our cases today. But if you are listening, reach out to us at jjnsolutions.com, and that goes for, I put on this outline, Jeff. That's sponsoring the show, because if you have any domain disputes, of course, you're party to a domain dispute, whether it's a UDRP, a URP, or you're party to an actual court case, or if you just receive some communication from somebody who's maybe threatening legal action against you, reach out to us. Certainly like to help really both sides, but domain investors specifically. And if you have any other legal issues with regards to your business, or need contract help or artist management, anything, reach out to us. So that's just the plug for JJN Solutions. And we want to jump to our cases. We'd like to get in and out of here 30 to 40 minutes now. So if you're following along, you can see our outline. It's there every week, dnlshow.com/outline. The first case today is a case BEARFOOT.com, barefoot.com. And as domain investors, if I saw that, I'd think, well, yeah, that's cool, because one, what a great name. We know barefoot, BAREFOOT, is a word. Barefoot can be a play on that, can be an extra thing. It's not as lucky as a rabbit's foot if you find it barefoot. I think I'd get out of the area. But anyway, so this case, barefoot, BEARFOOT, was a UDRP. It was a complaint brought by a company, Barefoot, spelled that way, BEARFOOT, LLC. They were self-represented. The respondent has a company, BRFT. They were also Barefoot, but we'll talk about the different spellings. And there was I can't say a lot going on in this case, but yeah, sort of a lot going on in this case because I felt like there was a senior user outside of these two parties who seemed to have, according to the trademark office, sort of senior rights to this type of name. But then there were so many companies using different spellings of barefoot and so on. Okay, so this complainant has a company, BEARFOOT, and they sell shoe wear, shoes and types of, I guess what did it say in the thing? It was a barefoot style minimalist athletic shoe for adults and kids. Okay, so they had filed well, I think what I'm going to do is throw it to you, David, and tell us about them filing for a trademark. If you remember the days, well, I'll help you. They filed for a trademark on November 9th, 2020. And
Yeah, so the 2020 trademark is not a word mark. It's just a literal, there's no literal element in that mark. So you look at it, you look at the description, you look at everything. The word barefoot does not appear there. Yeah, the word barefoot is like not visible there. So if I were doing a search, that would not have come up. And I think that was by design because they probably wouldn't have gotten even that registration if they had put the word barefoot in their application. So doing a search ahead of time would not have uncovered this. There are just so many barefoot trademarks out there. It's just crazy. Anyways, so this particular barefoot product, they had a for their designs that bear paw with a human footprint inside the bear paw. That's all it is. There's no literal element whatsoever. And based upon that, they filed this UDRP complaint. They actually did try to file a registration for barefoot in 2024. It was rejected as being confusingly similar to this bare feet trademark that has been around since at least 1993 as a registration and in use before that. So yeah, they didn't really have any clear rights, but what's really swayed David Bernstein was, oh, but we have like $4-something million in sales per year under our brand, and we have a barefoot.store domain name, and we get a lot of traffic there. And yes, SpyFu shows that they get a lot of traffic and they don't pay for any of it. They just have 6,200 visitors a month approximately, and they potentially have some sales. They're allegedly based out of Fargo, North Dakota, a little warehouse. Is it just a front for a business? Because I looked up that address. It's actually a furniture place for kitchen cabinets. So who knows? But anyway, maybe it's just a drop shipper. They sell sandals. So the respondent sells running shoes that have really thin soles. And that has become really popular amongst runners because runners like to land flat on their feet or on their toes or whatever. I don't know. They just don't want to land on their heels anymore. So they had weird misspelling of the word barefoot with the E at the end of bear. And then they decide, I'm going to buy the correct spelling of barefoot.com. And they did. They bought it from Perfect Domains. Perfect Domains or somebody before them acquired it for $1,100 on NameJet in 2012. There was no price on the Perfect Domains listing in 2023, but the respondent did acquire it. And now they've lost it in this UDRP complaint. They have, I think, a few more days, maybe 3 days left to file a ACPA action to stop the transfer. Here's what they did wrong. Domain name. Because they want to stop typo squatting. And they spend over $9,000 a month in PPC ads. This is a well-funded company and they're spending a lot of money. So I think there's going to be litigation. Well, what do you think, Jeff?
Yeah, we have another case from David Bernstein a little later on that we're going to discuss, which I think I agree with. But this one, David and I disagree. David Bernstein, um, disagree on the amount of analysis that should be done by a panelist in a UDRP case. So the couple things I want to point out. Well, first of all, let me go back to something you said at the beginning, which is that, or maybe Todd had said it, that there is a more senior user. That's not really relevant or hugely relevant in at least the first and second elements of the UDRP um, for this process. In other words, it doesn't matter that someone's senior for element 1 or 2, whether there's trademark rights or whether the respondent or the registrant has legitimate rights or interest in the name. It doesn't matter whether there's other trademark owners other than the complainant. All that matters is essentially whether this complainant could show that they have trademark rights and whether this complainant could show that the respondent lacks legitimate rights and interest in the name. So, but putting that aside, I don't agree with the amount of analysis David Bernstein did on um, all of the trademark issues in this case, because I think they're a lot more complicated than what should be figured out in a UDRP, where there's no examination of all of the documents, there's no discovery, there's no cross-examination, there's no, none of that exists. And for me, as a panelist, I would have just said, look, this is much more complicated than an obvious cyber squatting case, and therefore is outside the scope. And so, for me as a panelist, I don't agree with all the analysis that he did. But second of all, I just also think that even with his analysis, he jumps to too many. The panelist jumps to too many conclusions and assumptions based on assumptions that he makes that just have no basis in fact or in evidence that at least is explained here. To make assumptions that the respondent must have known about the complainant's existence because he cited other users of a similar trademark, or the impact or the effect of purchasing the rights of a similar trademark from another potentially even more senior user of a similar mark. That to me is not something that should be decided on a UDRP. I mean, those were the kind of things that really concerned me here. Because I don't
So
know.
Jeff,
We don't know
if
if
you
David Bernstein's right.
okay, so if this domain is older, obviously, so if the respondent filed an ACPA case in Arizona, we don't know the mutual jurisdiction. It's either the chief's offices in Arizona or it's in Delaware, the address of the respondent.
Yep.
So assuming that the mutual jurisdiction is in Arizona, it seems like it's a simple Ninth Circuit decision where, hey, a registration date predates the complainant's alleged rights date, and so therefore they have no rights to this domain name, period. They just can't get it. And so therefore it would stop the transfer. There could also be a Section 43A claim because the complaint allegedly has been disparaging the respondent as being a scam organization and trying to steer customers towards themselves as opposed to the respondent, which seems to have a serious business going on from what I could tell online. I think that would actually play better in Delaware in terms of damages and punitive damages. I don't know about Arizona, but
There's certainly a number. I mean, it wouldn't just be an ACPA claim.
Yeah.
I think, in fact, it would be just a general declaratory judgment that they have rights. That too could also be effective. But yeah, I mean, it's interesting as to who's infringing whom, and I just think David went too far in his assumptions and his findings, especially for this case that the UDRP that's only decided on a paper record and not even where responses are allowed necessarily. And I would not have gone that far.
So, to clear up some things for those listening, and you can look at the case at our website, dnlshow.com/outline. So this complainant was on Barefoot, BEARFOOT .store, and they're selling this shoe wear. And then this other company was really on the domain BEAREFOOT, sort of like bear, the word bear, and then BARE, like combined. So they came up with this word, and of course it looks sort of goofy. It looks like barefoot with an E in between the R and the F in the word, and it was. So they were on, the complainant's on barefoot.store selling shoe wear. The other company comes along and they're like, we're going to be barefoot with BEAREFOOT. And we mentioned there's, several other companies that are using barefoot. There's get barefoot, try barefoot, a bunch of stuff like that. But worldwide, there's companies using this. And you can imagine barefoot, you can say is, no shoes on your feet, bare feet or barefoot. But the point is, there was the reason I brought up, and Jeff, you made it clear, I'm used to, say in lawsuits when a senior user in a trademark, certainly much more important here. It's like you said, does the complainant have trademark rights, and is the respondent, targeting or really, targeting that complainant? Well, in this case, the complainant did file a trademark, and the trademark examiner, the trademark office, said there was a senior user, bare feet. So they didn't issue the registration, and then the complainant abandoned that trademark, and the respondent said, see, they shouldn't even have rights here to file this case, this UDRP case. And then David Bernstein, the solo panelist, said, well, they did show that they had rights by, showing common law rights. They showed business they had done. And the respondent said, well, how do you know that's accurate? That business, that's not like some audited financials or anything like that. We don't even know if they could just be supplying, And then David Bernstein says, well, this is not court. This is a UDRP. So it's up to me to decide, does it look like it's sufficient, the proof that they're making that they have been doing business as barefoot? And if you're saying that it's fake, then give me some evidence that it's fake. And the respondent didn't. So basically, David Bernstein said, yeah, so they do have standing here. We'll go to the second prong, and that is, does the respondent have legitimate rights to it? Does the complainant show that the respondent doesn't? And they felt like he kept using the word, saying, yeah, maybe he has rights with the BEAREFOOT, but when he wanted to buy that name barefoot in the aftermarket and then redirect it, David acted like, well, he bought this name knowing about the complainant and forwarding it, selling shoe wear. You could have done it under your original name with that extra E, but when you put it just with barefoot, it is confusing, and felt like you don't have you don't have legitimate rights to use it. Just the barefoot, they were using it before you. But when he gets to so David says the complainant's successful in prong 2, gets to prong 3 about bad faith registration, and says exactly that. You got that name. It's not like, the respondent said, I got that name because, one, he knew that's probably how people were spelling it more frequently when they're going to their website. But David felt like you did know that there was already somebody using that at the barefoot.store. So not only did say, hey, the complainant was successful showing that you registered this name in bad faith, your request for RD&H obviously is thrown out because this complainant has shown, that they've successfully proven all points of this. But anyway, so yeah, transfer. This guy, bought this name barefoot on the aftermarket, but because this complainant was using barefoot.store and they were in a similar business, David Bernstein felt like you knew about him, you got that name to um, basically take advantage of their mark and transferred this name. So, I agree with both of you that, yeah, this was not a great decision, meaning I think there was so many different people using the term barefoot that anybody could have picked this up. And then they're saying, so this particular complainant would have been successful against any anybody that bought this on the aftermarket. Just really concerned for when you're selling a name like this. So it's like you're saying really only this company has rights to it. I don't know. Okay, so I think it was a bad decision. This was a transfer. There obviously wasn't an RDNH, is what David Bernstein said. Any other comments you guys want to make on this before we get to the next case? I pretty much beat it up
No, I
there.
think there's actually 588 domain names that have the word barefoot in it, just for reference. And a lot of them do the same thing forwarding. Like, for example, barefoot-running.com/0shoes.com. So this is happening rampant. I would consider this to be a generic term. I remember a Shark Tank episode where somebody came up with this pitch for barefoot running shoes maybe a decade ago. So this is not the first person selling barefoot running shoes or sandals or any kind of footwear.
Yeah. Okay, we're going to go to our next case, but it is true. It became so popular the last 10, 15 years, these shoes that are like not wearing shoes. And David, you're right. Runners, usually when you're younger, now I need more cushion. I'm an old person. But when you're a younger runner and you're really, say, an elite runner, you like to have real thin, basically almost running barefoot, but you want some protection, and they usually like a real thin sole, molds it's almost around your feet. But and of course, any shoe company makes sense. They talk about barefoot and sandals and so on. But all right, so that name got transferred. BEARFOOT.com got transferred to the complainant by David Bernstein. He was the panelist in this case. Okay, the second case today is PremierPro.com, and I added this one because I knew immediately when I saw it, Premiere Pro. I'm like, all right, well, that could certainly go for Adobe has an editing software they've had for 30 years called Premiere, and they're the complainant in this case, and they're out of the attorneys Morgan Lewis and Bacchius. Have you heard, them, Jeff? They're out of D.C.
Yeah, they're a very big firm, very well known firm. So
Yeah,
yeah, they're
figured
pretty
they
big.
were. I mean, so Adobe, big complainant. I mean, well-known complainant in this case, Michael Gralla out of Florida. Okay, the reason I bring up this case, because I'll just tell you, I have a domain avidpro.com, and years ago, I became really proficient when I was making films on editing, and some editors will focus on one type of system and become an expert at using that system. Well, I used Adobe Premiere. There was also, I purchased an Avid Media Composer and spent a lot of time and a lot of money learning how to use that. And then, of course, there's a lot of freelancers in the film business, editors, and a lot of us, will come off as I'm an expert on this machine. I'm an expert on using this type of tool, this type of editing system, and so on. So when I saw this, I thought Premiere Pro. All right, well, what's the guy doing with the name? I can certainly see why Adobe would want it. Adobe has a product called Premiere Pro. I don't think they really have a trademark. I was looking at this. I mean, at this case, they have a lot of trademarks. Adobe Premiere, Adobe Premiere Rush, Premiere Rush. They have a product called Premiere Pro, and they have it. It's pretty well known in the Adobe product line. So they said, we don't have a registered trademark for Premiere Pro, but we certainly have common law rights in the Premiere Pro mark, and we've been using it for a long time. So Adobe just went through the standard. Do you want us to show? And they did evidence of using the Premiere Pro mark, and they submitted a lot of evidence to show they have common law rights to it, because once again, they didn't have it. It's not registered. And this case, basically, it's a case where I believe, and I'll throw it to Jeff, you first, and then to David, and that is this is a case where the respondent didn't respond, and his only, I think there is fair use here if you say, I use this particular tool. It's sort of like Corvette Pro. Yeah, you need to really respond back and show that you're using it in a fair use way, and it may be in a commercial way, but you really need to respond back, because when you have a big complainant, a well-known complainant like Adobe, make their case, you can't expect for a panelist, in this case it was James Bridgman, for them to say, well, hey, they could have been using this in a fair use way, because when you go to the website it says I think it said, did it say PP? It should have said PP, but I think it said, matter of fact, let me go to it real fast. I was there 1,000 times. I was like, why does it say, oh, it just says PR. Now it doesn't even, the complainant, Adobe, said that the guy was offering software, competing software. I went to the website. I don't see that, but Adobe provided evidence saying they were providing competing software, which is what ended up losing this case. This was also a transfer, but I wanted to go to you, Jeff, and say, okay, so there was no response here. Tell us what you think about the facts of the case and the decision, but if there was a response, what would have been a potential winning response for the domain owner here?
Yeah. So look, I unlike you, I did not know that Adobe had a product named Premiere Pro. That's not the type of software I would have, been familiar with necessarily. Um, but look, calling a product Premiere Pro is so general; it could describe lots of different things. So if they had filed a response saying, yeah, we have this product for a completely different class of goods and services, or we're planning on using it for these other things that have no relation to Adobe's products or services, um, it's a fairly easily winnable case. Not responding is obviously what did this person in. Um, and I'm not sure why they didn't respond. But yeah, there's a lot of different scenarios where I could view this being a successful case for a respondent. Um, any product you have different levels of products. You call one version of it Premiere and another version of it Premiere Pro. I don't associate that, and users don't necessarily associate that only with Adobe. But like I said, not responding doesn't do you any favors, especially in a case like this.
There are over 5,100 trademarks that comprise the word premier in various industries, from paper towels to laboratory equipment to textiles and music stuff. And Adobe only owns the marks that have Adobe in front and Adobe Premiere, Adobe Premiere Rush, and so forth, but they don't have Premiere Pro. But what this guy did was he has that PR logo, which I recognize being the Adobe logo for their Premiere product for video editing. And the top of the website, the address bar, just above it, the tab that says video editing. And I don't know if this guy's intent was to provide video editing services with uh, Adobe Premiere Pro or training. I took a Premiere Pro training course at a local college a decade ago. So anyway, um, this guy didn't have a finished website to say that he was selling the product. I can't verify that. It doesn't look like he would have. It's really hard to make a competing product like that, so I don't think so. But he could be selling like older products that you can actually download or like, had licenses for that are actually authentic. But I didn't see that either. So I don't know what this guy was planning on doing, but he had a half-assed website that started something, and he got nailed by not completing it and getting caught in this UDRP and not responding. So it was savable if he had done it right, but he didn't.
Yeah, many different ways, and you're right, David. In the address bar, it says, find a videographer, Premiere Pro, and it, so he could have specifically offered services using the Adobe product. But as Jeff then mentioned, Jeff, it could be, we've been part of Premieres, right? I had a premiere on some films that I've released, but also in the theater business. It's, a premiere, and a premiere pro in that business could be somebody who puts together, a launch of a new production, it's sort of a party, or, but the point is it can be used, premiere, the word, for a lot of different products, uh, a lot of different subscriptions, like you were mentioning. It could be, you offer your product online, you have your free product, your Premiere product, your Premiere Pro product. But this person referred to an editing software and used Premiere Pro, and a panelist thought it looked like Adobe's logo, and then not responding. You're just like messing. You're showing that you know of the complainant. It looks like you may have targeted them, and then you're not saying what you plan on doing with it. And although you may have some fair use rights, you really need to be specific. But if this person wouldn't have had anything on there then and not responded, meaning no website, or like a lot of us have, just a for sale page, I would have liked to have seen the reasoning. One, the complaint would have been different because Adobe wouldn't have said, hey, they're using our mark and they're selling services, or similar to our product. So I would have liked to have seen how that went with a no response. But yeah, so this needed, there can be plenty of uses for Premiere Pro, but you'd have to have a real legitimate use of it and then answer. So that's why this one was lost. Premiere Pro, that's the second transfer for today. Anyway, interesting case to me, because I'm like, listen, you really need to make sure if you are going to say, I'm aware of the complainant and I was offering the complainant's product or their service exclusively, and I have a fair use right to do that, you need to explain yourself. But okay, so this that was a transfer. We got a final case today. CreditGPT.com is our final case for today. And in this case, there's a company, I believe they're out of Northern California, from what I thought they were. Where they went, but it was a Delaware company. David, do you recall it was CCP3 LLC was the complainant, and I know they were represented by Grant Attorneys. It says just say USA, but okay, yeah, based in Oakland, but they were organized in Delaware, so not uncommon. This was also David Bernstein was the solo panelist. So this complainant said, hey, we're offering these credit services, and we offer it, AI style, and our name, Credit GPT. They filed, or they filed to register a trademark, but the trademark office said no, or basically, did they allow them to file it in the supplemental registry? It was because
Yeah, that's all they have.
okay,
Supplemental
so
registration.
the
Because
examiners thought it was
GPT
just
is
too
descriptive.
generic.
Yeah,
Okay, so
exactly.
they have this supplemental registration, and now
I think it was still an application, not even a registration. It was an application still for the supplemental register.
okay, that's why I
So,
didn't even make it past that. Now,
right.
okay, the factual, I mean, okay, so this one, well, this one got turned upside down from basically step one, that I'm just giving it away now, that the panelist David Bernstein, I'll throw it to you, Jeff. You said you liked his decision here. He said they didn't even have rights to go forward with this. Was that because it was just going to be a supplemental registration, and like you said, it wasn't even really registered in the supplemental registry yet? So he just felt like, hey, not you have no standing here. And then he didn't. He went ahead and talked about the other two, you know, prongs on this case. But how did you view this case, Jeff? And if you were a panelist,
Yeah,
would you have done the same thing?
I mean, absolutely, right? Even if they had a registration on the supplemental register, that's still not, that still doesn't count for as a national registration under the UDRP. That's been well established since the very beginning, that that your mark, in order to use a federal or national registration, it has to be on their main register, not on something like the supplemental. And so then the analysis would switch to whether there was common law rights. And according to David Bernstein, there was nothing submitted in terms of facts that would establish common law rights, no sales figures, no um, website traffic, public recognition, social media, press coverage, nothing like that was submitted. So, they failed even the standing requirement. And of course, because of all the issues it had on the descriptiveness of its initial application, that it wanted to be on the main national or federal register, because of the reasons the USPTO said that this is generally descriptive anyway. Um, there could be no rights, or they couldn't establish that they themselves had rights or legitimate interest to the name, nor could they even come close to establishing um, that the respondent didn't have rights to this at all. And of course, because they couldn't establish that, there's no way to establish bad faith. And ultimately, it's a finding of RD&H, because if you can't establish any of the elements, you shouldn't be using the UDRP.
Yeah, you're right. So the application never matured to registration. It was published for opposition. And then OpenAI filed a extension of time to request extension of time for an opposition. And that was enough for this applicant to withdraw their application. And they did that in April. And it looks like they did that right around the same time as they filed this complaint. So that is interesting that they would file this complaint anyway after receiving that notice of opposition from OpenAI. That is suspicious.
Regarding the RDNH, so David Bernstein commented, this is a, what do you say specifically? This is a, let's see here. This is a poster child for RDNH. And Zach made a comment on the ICA digest that he agrees that basically, primarily because the complainant was represented by counsel, should have known better, and knew that they really didn't have standing. They didn't have a solid or common law trademark to credit GPT. And I thought it was interesting, this respondent was on creditgpt.io, and then he picked up the .com for $4,999. I thought interesting as a domain investor, that seemed like a, for the business he's in, very reasonable buy. And I was thinking, GPT, I guess that's, he considered credit generic, of course, and then GPT was the type of AI that he was using, and we all know Chat GPT, but I guess GPT is really generic. David, do you think creditgpt.com for $4,999 was good buy?
Yeah, actually, they're not going to be able to, if that's how much they paid for it, that's a good price, because they weren't going to get their trademark. It looks like the application's still alive or not. I can't really tell, but something's up with it. There's no final notice on the USPTO database. So, but yeah, they got the domain name just by paying for it. That's amazing. Even after they filed the UDRP against it. I don't know, maybe they were just trying to find out who the owner was and, decide to make a deal.
I think
Especially
domains
after
are even more
receiving that
valuable
OpenAI.
when, no party can really secure a registration, a trademark registration, because it's too generic. I feel that way about paynow.com, because you cannot trademark PayNow in the payment space. It's considered generic, but yet it's really powerful to own the .com. So I think, like in this case, Credit GPT is a great domain name if you're in that space, and everyone's fighting for, to use, I guess, that term. If there's at least even more than one party, owning the domain name means a lot. I was going to mention, before we shut it down for today, about NamesCon. There's going to be a lot of announcements coming up, and one of them is they're having, in addition to the main room, the main stage where a lot of the sessions are going to happen. They're going to have this white room. And I know that sounds racist. Okay, anyway, they have this white room, and it really is more for interaction with the session, with the people that are giving presentations. For example, I said that would be a perfect spot for domain investors, for attendees to interact with some attorneys who are willing to, basically instead of just giving a presentation on stage where it's one-sided, you're just hearing people talk and you can't ask questions, you can ask some questions, specific questions about disputes, how to use names, and so on. We know it's happened before, but I just wanted to bring up NamesCon is really planning to load up this year with some great sessions, some interactive sessions, some new ideas. And if you plan on going and you haven't got your ticket yet, you can save 20% by using the code TR, as in Tom Ryan. Okay, Todd Ryan too. TR20. So those 4 digits, TR20, and you'll get 20% off your ticket price. I sure hope to see you there. I know for a fact I'm going to be roasting the entire industry. And then, of course, I'm going to be on stage with Rick Schwartz on day 2 towards the end, talking about the Beanstalk Challenge, in addition to some other great things that I know are going to happen, and I can't wait for their announcements. So NamesCon team been working very hard behind the scenes. I know this is going to be, I already know from some of the ticket counts that this is going to be probably the biggest NamesCon ever, certainly since the first 1 or 2 when they were, I think the second or third one was pretty big about 8 or 9 years ago. But anyway, so I look forward to seeing everyone there. I know Jeff's going to be there. We're going to be representing JJN Solutions, and really look forward to it. It's not till November 11th and 12th in Miami. But David, I know I'm just going to ask, but I know you probably won't make it. But are you certainly not going to go, or are you considering it? What are your plans?
No, I'm not going to make it. I don't have energy for traveling.
No, I knew you weren't. So I look forward to seeing several people in the audience I know are going to be there. I sure hope, Brad, you can swing by. I know it's not too far for you, but Brad's a friend, one of the friends I haven't met in person. Of course, KW I hang out with, so I look forward to seeing her. Well, thank you everybody for being here. We'll be here next week. We're trying to go 30 to 45 minutes, so it's easy on the ears, easy on the replay. You see today we went a little long because we try to complete these cases, but appreciate if you want to hear or you want to listen on replay, you can do it right here on X or on YouTube where we're streaming. And then, of course, we have replays on Spotify and Apple Podcasts. But thanks again this week on the DNX show. In a couple days, Summit is co-hosting with me because Josh is on holiday. But Josh said, hey, I can probably drop in. I'll try to remember, just so we can talk about domain name investing. And that means open discussion. Everyone's welcome on stage. We want to have a nice 90-minute discussion. That's on Thursday morning, 10 a.m. Pacific, 1 p.m. Eastern. Until next Tuesday, take care of yourself. Enjoy the rest of your day or evening wherever you're at. Thanks for being here.